In the previous section, we examined how the promissory note, deed of trust, and mortgage each function within Arizona's real estate financing system, forming the foundation of how debt is created and secured. Building upon that knowledge, this final section brings those elements together to outline the legal documents and procedures required to secure a loan in Arizona. Understanding this process is critical for licensees, lenders, and borrowers alike because compliance with Arizona's statutes ensures that financing transactions are lawful, enforceable, and protective of all parties' rights. Overview of the loan security process. Securing a real estate loan in Arizona is a multi-step process that transforms a borrower's promise to repay into a legally enforceable obligation backed by property. This process is governed by a combination of state statutes, chiefly ARS, FGAR 33-701 through Paragraph 33-821, and federal regulations under the Truth in Lending Act, TILA, and the Real Estate Settlement Procedures Act, RESPE. Together, these laws define how lenders must document, disclose, and record financing agreements. The key concept in Arizona lending law is that a loan is not fully secured until both the debt instrument, the promissory note, and the security instrument, either the deed of trust or mortgage, are properly executed and recorded. Without these legal steps, the lender's claim against the property is incomplete and unenforceable against third parties. 1. The promissory note, creating the debt obligation. The process begins with the execution of the promissory note, which establishes the borrower's personal liability to repay the loan. This document outlines the essential terms of the debt, including the principal amount, interest rate, payment schedule, and default provisions. It may also include clauses such as acceleration, allowing the lender to demand full repayment upon default, prepayment penalties, or late fees. For example, a borrower in Scottsdale signing a promissory note for a $500,000 mortgage loan commits to repay that amount with interest over 30 years. The lender, in turn, agrees to disperse the loan funds under the terms specified in the note. The note alone, however, does not secure the lender's interest in the property. It must be paired with a separate document that creates the lien. 2. The security instrument, deed of trust or mortgage. To secure repayment, Arizona law allows lenders to use one of two instruments: the deed of trust, the most common, or a mortgage. Under a deed of trust, 3 parties are involved: the trustor, a borrower, the trustee, neutral third party, often a title company or attorney, and the beneficiary, lender. The borrower conveys temporary legal title to the trustee, who holds it in trust until the loan is paid off. If the borrower defaults, the trustee may conduct a non-judicial foreclosure, a trustee's sale, without going through the courts, provided all statutory notice requirements under ARS, paragraph 33-807 through paragraph 33-810 are met. Alternatively, when a mortgage is used, only 2 parties are involved: the mortgagor, borrower, and the mortgagee, lender. The mortgage creates a lien rather than transferring title, meaning that foreclosure must proceed through the courts under ARS, paragraph 33-721. This judicial process ensures oversight and protects the borrower's right of redemption after the sale. Both instruments serve the same purpose: to secure repayment of the promissory note, but differ in structure and foreclosure procedure. Arizona's preference for deeds of trust stems from their efficiency and reduced costs for both parties. 3. The loan application and disclosure requirements. Before any loan is finalized, lenders must comply with both state and federal disclosure laws designed to promote transparency and consumer protection. Under TILA, 15 U.S.C., paragraph 1601, and RESPE, 12 U.S.C., paragraph 2601, borrowers must receive detailed information about the loan's terms, interest rate, and closing costs. The loan estimate, LE, must be provided within 3 business days of loan application, summarizing key loan features and projected closing costs. The closing disclosure, CD, must be delivered at least 3 business days before closing, giving borrowers time to review final loan terms. Arizona's ARS, paragraph 6 to 841 at SEQ, further requires that escrow agents ensure all loan funds are properly dispersed in accordance with the lender's written instructions. Purpose to 4. Recordation of loan documents. Once executed, the deed of trust or mortgage must be recorded with the county recorder in the county where the property is located. This recordation gives constructive notice to the public of the lender's lien and establishes its priority against other potential claims. For instance, if a homeowner in Mesa refinances their property, the lender records the new deed of trust, which formally replaces the prior lien on public record. Without recordation, a lender's security interest might be subordinate to subsequent liens or claims, jeopardizing their ability to foreclose or recover funds in the event of default. 5. Issuance of title insurance and escrow coordination. Before recordation, the title company issues a preliminary title report, also known as a title commitment, confirming that the property's ownership is clear and identifying any encumbrances that could affect the lender's lien position. Once the loan closes and the documents are recorded, the title company issues a lender's policy of title insurance, guaranteeing that the lender's lien is valid and has first priority. Simultaneously, the escrow officer ensures all loan funds are distributed correctly, paying off prior liens, taxes, insurance premiums, and any other costs listed in the settlement statement, HUD 1 or CD. This coordination ensures that the lender's interest is fully protected and that all parties comply with statutory and contractual obligations. 6. Post-closing requirements and reconveyance. After the borrower fulfills the loan obligations, the lender, beneficiary, or mortgagee must direct the trustee or record a deed of release and reconveyance for deeds of trust, or a satisfactions release of mortgage for mortgages. This step clears the lien from the property's title and restores full ownership rights to the borrower. Failure to record the release in a timely manner can result in penalties under ARS, paragraph 33707, protecting borrowers from lingering encumbrances. Practical example of the full process. Consider a buyer in Gilbert purchasing a $450,000 home. The buyer applies for financing through a lender, who provides a loan estimate and later a closing disclosure. The buyer signs a promissory note and a deed of trust, naming themselves as trustor, the bank as beneficiary, and a title company as trustee. The title company confirms clear title through a preliminary title report. The escrow officer collects and disperses funds, and the county recorder records the deed of trust. After 30 years of payments, the loan is fully satisfied, and the trustee records a deed of reconveyance, restoring complete ownership to the borrower. This seamless process, backed by Arizona statutes, illustrates the efficiency and legal safeguards of properly executed loan documentation. Discussion. What 2 documents must be executed to secure a real estate loan in Arizona? Answer. The promissory note, which creates the debt, and the deed of trust or mortgage, which secures repayment through the property. Why is recordation of loan documents important? Answer. Because recordation provides public notice of the lender's lien, establishing its legal priority and enforceability against third parties. What purpose does the deed of release and reconveyance serve? Answer. It removes the lien from the property once the loan is paid off, restoring clear title to the borrower. Review summary. Securing a real estate loan in Arizona involves a series of critical steps designed to create, secure, and protect both the borrower's and lender's interests. The promissory note establishes the borrower's personal obligation to repay the loan, while the deed of trust or mortgage secures that obligation through an interest in the property. Federal laws, such as TILA and RESPA, mandate disclosure and transparency throughout the process, while state laws under ARS, paragraph 33701 through paragraph 33821, and paragraph 6 to 841 et SEQ govern execution, escrow disbursement, and recordation. Title insurance, escrow coordination, and proper recording at the county level complete the process, ensuring that the lender's lien is legally enforceable and the borrower's ownership is properly documented. Arizona courts, through cases such as Patton v. First Federal Savings and Loan Association of Phoenix and Mid-Kansas Federal Savings and Loan Association VAR. Dynamic Development Corp. Continue to uphold these statutory procedures as essential safeguards in maintaining fairness, efficiency, and confidence in Arizona's real estate lending system.